This is Henry Quillian at Taylor English Duma. I'm here with quite a number of my colleagues. We're here today to discuss recovery of attorney's fees under Georgia provisions, Georgia state law provisions, and we're going to be discussing not only how do you recover them, but also how do you defend against them and how do you appeal from an award of attorney's fees or from the denial of an award of attorney's fees. As those out there in the internet world have always heard, we are not providing direct legal advice. We are giving guidance to how litigators who are licensed attorneys in Georgia might pursue going about handling a case. And if you are not an attorney, you should seriously consider getting your own attorney when dealing with any of these issues. As we will discuss, significant amounts of liabilities can result out of these statutes. They're not to be toyed with, but they are very confusing and they are impactful on cases. We have presenters other than me today who are colleagues of mine who have dug deeply into various subsections of various statutes in Georgia relating to attorney's fees, and they are Don Boyle, Catherine Banich, Vanessa, all of our litigation department. And we have numerous other luminaries in the room who can comment and share their experiences with respect to these issues. So first I'd like to introduce Don Boyle. He is going to start off, as he will describe, talking about OCGA 91514A and how liability can arise under that particular statute. And then we will go on from there through 91514B, OCGA 51780, and then ultimately OCGA 91168E. So with that, please welcome Don, and we'll kick this off.
All right, thanks, Henry. As Henry always says, start with the rule, or in this case, the statute. I'm talking about 91514A only. That paragraph, it's a little lengthy, but we're going to break it up. It says, in any civil action in a court of record of this state, reasonable and necessary attorney's fees and expenses of litigation shall be awarded to any party against whom another party has asserted a claim, defense, or other position with respect to which there existed such a complete absence of any justiciable issue of law or fact that it could not be reasonably believed that a court would accept the asserted claim, defense, or other position. Attorney's fees and expenses so awarded shall be assessed against the party asserting such claim, defense, or other position, or against that party's attorney, or against both in such manner as is just. So that's what the section says. I think key points to look at right away are it's mandatory, not discretionary. It says shall be awarded. It applies to a claim, a defense, or other position. So it could be the plaintiff, it could be the defendant in the case. And the standard is it's got to be a complete absence, right? Complete absence of any justiciable issue of law or fact. And also to be aware of, it could be your client that gets hit with the fees and expenses. It could be you, the attorney, or both of them. Procedurally, the court has to make express findings. In other words, they can't just hit the party with the sanction. It has to lay out in an order why the award is just. If it doesn't make those kinds of findings, the award's going to be vacated and sent back to the trial court. The court has to hold an evidentiary hearing after due notice to the non-movement unless the non-movement waives the hearing. Now, the Supreme Court recently, in a case from last year, Justice Namias said, "It is good practice," I'm quoting him, "good practice to make a specific request for a hearing in response to a motion for attorney's fees, since that will remind the trial court of the hearing requirement and weigh against any finding that a hearing was waived." That's pretty common sense advice, right? I hope if any of us receives in the mail or otherwise a motion for attorney's fees that you promptly let the court know you oppose the motion and ask for a hearing. Okay, so that's important. And the fees awarded have to be those that are attributable to the sanctionable conduct. There are many cases that say the court can't just enter what they call a lump sum award. In other words, even if the moving party is able to show it really incurred these fees, they were reasonable for the work done, they have to be the fees that were incurred in responding to the sanctionable claim or defense. So if it's just a lump sum award, that's going to be vacated and sent back as well.
What does that tell us about how we would go about keeping our records in the event we think there's a completely unsupported claim in a lawsuit against our client?
Right, good point, Henry. It would be good practice if you think this is coming up in addition to the way you normally give your client a description of the work you're doing as you do your bills, to the extent that you think there's going to be a distinction between the sanctionable, responding to the sanctionable claim or defense and other work, that you have that separated. Otherwise, you're going to have to go back and try to reconstruct it later, and that can be difficult. Interesting point. What happens if the party that later moves for the fees had moved for summary judgment and that was denied, right? Moved for summary judgment, it was denied, and then there's a trial. Can they recover the fees for the sanctionable, for the claim or defense? The courts say that if the summary judgment motion or a directed verdict motion is denied, then if an award is made, it has to be vacated in all but exceptionable circumstances. So they lay out that there can be a case. They say courts can't be infallible, right? So the trial court may have, say it was the defendant, and the defendant moved for summary judgment, motion is denied, case goes to trial, defendant wins, and then defendant moves for 9/15/14 sanctions. Well, probably the defendant's not going to win on that because his motion was denied. But they say, well, maybe the trial court should have granted the motion, right? So they lay out that possibility, but it's pretty rare.
What if a witness recants earlier affidavit testimony that was what gave rise to the question of genuine issue of material fact that caused the denial of summary judgment?
Do you know of a case like that? That sounds like something where that could happen. Right. This goes a little bit into A and B. You have a good faith defense. The statute says no attorney or party shall be assessed attorney's fees if the party had a good faith attempt to establish a new theory in law, if it's based on recognized presidential or persuasive authority. So you have that good faith defense that you would raise. Also, fees incurred in moving for the sanctions award are recoverable. Now, when do you make this motion as the moving party? You can make it at any time during the litigation, but then you also have 45 days after final disposition of the action, which is what this case has said. That doesn't mean you have to wait until the end of any appeals. It just means when the case is over below, then you have 45 days from that to move, if you haven't already. The award's made by the court without a jury, and it's enforceable as a money judgment. Any questions about war stories or anything?
Does anybody know of a circumstance where a 9/15/14 motion has been filed in the middle of litigation before there's been any determination as to the merits? For instance, somebody raises the defense and there's no basis in that defense, and so the plaintiff just files a 9/15/14 motion saying I had to think about or try to go find evidence or interview my client about this alleged defense?
Not in state court, but in federal court. Under some very similar standards we filed before we had an actual victory. It was based on a series of documented bad faith type conduct using similar standards as 9/15/14. We had some perjured testimony and some mischaracterization of the law and ended up getting the reward. So it's conceivable, and you certainly don't have to wait until you prevail on 9/15/14 to file your motion and win it.
Now, I do have a bit of a war story. I think it might help sort of illustrate this, because so far I know it's been a little bit dry just telling you what the rules are. I had a case about 10 years ago my law firm was working as what they call a SAG, a Special Assistant Attorney General for the state of Georgia. We were representing the Georgia DOT. And there was a contractor, Douglas Asphalt Company, that had, they'd done a lot of work in South Georgia paving the interstates. And some of that work turned out to be defective. And when the department went in and started investigating, they took core samples out of the highway, took them back to their lab, and determined that the asphalt mix hadn't been properly put together as per the contract. Now in Georgia, you had no idea about this, I'm sure, but in Georgia, you've got the rock, the asphalt, the rock, then you've got the tarry stuff, the asphalt, and then you've got to put a certain amount of lime in there as well, because the lime helps bind the two of them together, and there's a specific percentage amount that has to be used. Well, it turned out Douglas Asphalt, the contractor, had not done that. So this mix was falling apart. So you're starting to get cracks in the interstate highway near Brunswick, and it was starting to get potholes and stuff. So the department went in and said, look, all these projects you did, Douglas, you got to tear them up and do it over. So we had huge litigation about that. And we were in Fulton County, we were in Turner County, which is South Georgia, we were in Coffee County, we were in Cherokee County. Now the department's test was not something that was pulled off the shelf off of the standards book. There was actually a guy at the department's laboratory who came up with his test about how to analyze the mix and determine how much lime was there. And he did a whole bunch of tests before the litigation started, and then once we got into litigation, we said, we'll keep doing the tests. So we were using that methodology. And we're about 2 years into litigation, and this was in 2005, when the Tort Reform Act had just been passed, and Georgia had just adopted the Daubert standard. So the other side, the defendants, filed a Daubert motion to exclude all of our evidence because they said the methodology wasn't reliable. We had a 4-day Daubert hearing in Turner County. It was clear from the first day the judge was going to grant the motion, but we had to go through a 4-day hearing. And after
Douglas Asphalt from Turner County?
No, they're from Coffee County. They're from Coffee County. But one of the projects was on I-75 in Turner County. So anyway, then 3 months later, the judge issues about a 40-page order going through all the reasons why he thinks that the methodology was unreliable, grants the motion, and says all this evidence can't come in. Then about a year and a half later, or more than a year and a half later, Douglas decides, okay, well now Douglas says, we're going to move for all of our attorney's fees incurred in all the litigation in all the courts, because it all goes back to this lime test. And so they file the motion, their attorneys go up, they testify, and the judge thinks about it and issues about a 3-paragraph order hitting us with $400,000 in attorney's fees and $200,000 in expenses. So we took that up to the Court of Appeals, and Court of Appeals reversed, thank goodness. First of all, there were a couple of things wrong with what the judge had done. The judge has to specify, is the judge awarding the damages, the fees under 915.14a or b? The judge didn't do that. That was enough. Also, the fees that were awarded weren't shown to be attributable to the test or to the conduct. So that wasn't enough. That was a lump sum. Also, and he didn't make any specific findings of fact, which is what the judge has to do that in the 915.14 order, and our judge didn't do that.
Don, is that then final, the Court of Appeals decision, or does the trial court have another go at it?
Well, that's the interesting thing. It went back, but that was never, it never continued after that. But it would, yes, you're right, it would go back. So anyway, so that's just an example of how it can go.
Let me ask you this, Don. I've got a situation right now where we were awarded 915.14 attorney's fees in a divorce case.
Right.
And the other side applied for permission to appeal that.
Right.
On all the grounds you're talking about.
Right.
The Supreme Court said no and quickly remanded it. And I am now threatening contempt because the order in this case says shall pay within X days. That's what the trial court's order. said, but
Sure.
you read something can be enforced as a money judgment.
That's right.
If that's part of the statute, am I in trouble, threatening, contempt?
Well, I mean, I don't know if you get in, I mean, I think you're within your rights to try to enforce it. I mean, that's the question, yeah.
But by contempt would be the question.
That seems right to me.
It looks, I mean, it sounds like it's an order to pay it if he says
Yes.
he'll pay it
Yeah,
in the next days.
right.
And another thing that I'm doing with that I found interesting, obviously we enforce it as money judgment also, and I called the state court of Cobb County to ask them about what they're doing right this minute with respect to garnishments against banks. And they said, we're full speed ahead. That they do send some sort of notice to the bank. I haven't seen it, but I assume it's something along the lines of don't hold any Social Security payments or Medicare payments or anything like that. But I don't know.
Just real quickly before I turn it over to Catherine, so and you were starting to get into this on the appeal. The appeal of the award is a discretionary appeal, which is, I think, at least in my experience, I don't see that nearly as much as the interlocutory appeals. It's similar to an interlocutory appeal. The distinction being you don't get a certificate from the trial judge. You have 30 days from the order to file an application for an appeal, for a discretionary appeal with the Court of Appeals. So the Court of Appeals doesn't have to take it. The other side has 10 days to respond. By statute, the Court of Appeals has 30 days to decide on the application whether they're going to take the appeal or not. And then it would go up and proceed like any other appeal. The standard of review under 915-14A order is any evidence. The Court of Appeals must determine whether the claim asserted below, or a defense, had some factual merit or presented a justiciable issue of law. This applies to denials of the motion as well. So so you could seek a discretionary appeal of a denial of the motion for fees under 915-14. As you read the cases, you find that the cases usually go on, the issues usually go to sufficiency of the findings by the trial judge, like in my Douglas Haswell case I talked about, and the good faith of the non-moving party can also be very important. So, and I think with that, I'll turn it over.
Thank you.
Thank you, Don. If you don't know me, I'm Catherine Banich, and I'm also one of the commercial litigators here. And I'm going to talk about subsection B, which is a little bit different from subsection A, in that A is mandatory. So if the standard is met, the judge has no discretion. The judge has to award attorney's fees under subsection A. Under subsection B, it's discretionary, and there are really three different standards under B. The first one is it lacks substantial justification. That's simply another way of saying it was substantially vexatious, or frivolous, or groundless. The second type of standard is that it was interposed for harassment. The claim or the defense was interposed for harassment. And then lastly, a separate standard is whether or not the party or the attorney unnecessarily expanded the proceedings. And so again, subsection B, just like subsection A, is applicable both to the client and to the attorney. And if any of you have practiced under federal law, the standards are very similar to Section 1927, which is a way to get attorney's fees against a law firm or an attorney, and the inherent authority of the court. It's a very similar standard. And as a practical matter, what I've found in handling these cases, both in state and federal court on these very similar standards, is the kinds of conduct that you see that will result in these kinds of awards. And I see this over and over again, and that is if you are misstating or mischaracterizing the law, especially when you're bringing the action. If you've got what would ordinarily be maybe a great tort, but you're missing an element, and when you go to quote the elements of the tort, or maybe it's a statute, and you intentionally omit the inconvenient parts, as you head down, you have increased the likelihood that you are perhaps going to get an award of attorney's fees against you for the entire litigation, because that, if you had no good faith basis to bring it and you're not honest with the court, and you're not arguing for a good faith expansion of the law, then that is one ground that I've seen over and over again where courts, we've gotten awards of attorney's fees, where someone has mischaracterized, misquoted, or omitted certain parts of the law that are inconvenient. A second way that I frequently see attorney's fees awarded is you start a suit in good faith, which you're entitled to do, and you get into the litigation and suddenly you find out the evidence is not what you thought it would be when you first filed your suit. If you're on the defense, like I frequently am, the smart thing to do is send your letter, even if you're not proceeding under 51780, which requires ante-litem notice. 91514 doesn't require ante-litem notice, but it's always a good idea to send it, because you can make a case for an unnecessary expansion of the proceedings and the lack of good faith on the other side if you've highlighted for them why their case isn't supported factually, it isn't supported by the law. So that's the second kind. Failing to dismiss or simply ignoring a bad faith letter once it comes to light that the evidence was not necessarily what you thought it would be when you first filed your suit.
Do you typically make that a demand or a request?
It should, number one, it should be a demand. It should not be a request. And what I've seen on the other side is a tendency sometimes to want to bargain and say, well, we'll dismiss if you'll promise not to do it again, as either typically a face-saving mechanism. But courts have later found that if in the face of a demand like that, you start to put conditions on it and try to bargain, then that's more evidence of expanding the proceedings and acting in bad faith. So, number one, if you think you might want attorney's fees, it should be a demand. It should be an unconditional demand. And if you're on the receiving end and you think you might have what turns out to be a lawsuit with no basis, then your obligation is to dismiss it immediately and not ask for conditions or bargain, etc. Lastly, I think and more rare is, and this is my one war story, is where you see lawsuits that are interposed for an improper purpose. And that really gets into more of subjective intent. The first two standards are more objective. And what you typically do if you want to establish that a case has been brought for an improper purpose, is you can look to pre-suit conduct. You cannot get an award under 91514 for pre-suit conduct or conduct in other cases, but if you have a litigant who is bringing a lawsuit as a shakedown, we had this case when we represented Chase Manhattan at one of my former firms. We had this fellow who would pay his loans off but would make his payments short every month, and when he would get to the end of his amortization schedule, if he wasn't already in default, he would then demand a cancellation of his security deed. And there's a statute that says if you don't cancel security deed, then it gives rise to a claim for damages plus attorney's fees. And he did this not only to Chase twice, but to several other banks. So we went and got all this evidence that he had filed the exact same lawsuit against multiple banks. In addition to that, I think we found something like 60 lawsuits that he had filed around Fulton County in the metro area that were just absolutely frivolous, including suing his doctor because he had to wait 10 minutes for an appointment. And he earned a lot of money doing this. And so we got, as a condition of our attorney's fees award, which helped make it enforceable, we wrote it as a condition of the order that he had to pay us in full or he couldn't file any more lawsuits in Fulton County. And of course, if you look at the statute itself, if you get an attorney's fees award, someone dismisses and tries to refile, those become your costs. And they cannot refile the suit unless they paid your attorney's fees in full. Wanted to add just a couple of things to the appeal. The standard of review for subsection B is a little bit different than A. It's because this provision is now discretionary. The standard on appeal is it's an abuse of discretion, as opposed to any evidence with the first subsection. It is a discretionary appeal, but I'd like to add that if there is a final judgment that's otherwise directly appealable, you can lump 91514 into it, and then it would become directly appealable as part of your final judgment. But the thing to watch out for is if the final judgment gets dismissed for any reason, then you no longer have a basis for a standalone appeal of your attorney's fees, and that would be dismissed as well. And That would include a post-judgment award of attorney's fees. If there's a judgment and it's on appeal and there's a post-judgment award of attorney's fees, then even that post-judgment award then becomes directly appealable as part of the final judgment.
Should you both directly appeal and move for a discretionary appeal, or apply for a discretionary appeal simultaneously so that your main judgment gets affirmed, you'll still have your attorney's fees?
That's a good question. And one thing to watch out is if you take a discretionary appeal, and you've got to do that within 30 days of your order, if the Court of Appeal says no, that is a decision on the merits, and it's res judicata for any subsequent appeal. So you can't take a second bite of the apple. So if the two things occur simultaneously, you've got a 30-day deadline to do your discretionary appeal. And frankly, I don't see that it would hurt if you took a discretionary appeal and also lumped your 9/15/14 in with your final judgment, so long as your timing is not going to make you miss your jurisdictional deadline for either types of appeal.
Okay. Is it under OCGA 5635A10 that awards of attorney's fees are subjected to a discretionary appeal?
Yeah, I believe so. That sounds about right. I know it's 5635. I thought it was AD, but something like that.
And I noticed that statute actually says that awards of attorney's fees are subject to discretionary appeal. It doesn't say anything about denials of an attorney's fees award. Do we know, Don, Catherine, whether you can appeal using discretionary appeal a denial of award of attorney's fees?
Yeah, I mean, there are several cases reported cases where that's been done. I don't think I saw that the court actually really laid it out, but they just sort of recited the fact that this is a discretionary appeal from a denial. And there are a couple of those cases.
So one of those might be Southland Outdoors versus Putnam County
That's one.
at 265 Georgia Appeals 399, 2004.
Yep.
Yes.
Okay.
Let me ask you, you mentioned 51, what of the abusive litigation statute?
Yes.
Now, the notice is a condition preceding to claiming damages for frivolous litigation, but those damages are in addition to attorney's fees, aren't they?
I believe that's correct. Vanessa has
That's the
prepared
difference-
that topic.
That's the difference
Yeah.
between 51,780 and 91514 is 91514 only entitles you to attorney's fees and litigation expenses. If you're seeking some kind of additional damages, you've got to go through 51,780.
This could be a very good segue into Vanessa's part.
And I don't think you get to double dip. I think
No,
that
you can't double dip.
if you've gotten your 9/15/14, then you're limited to your other damages if you bring a
So,
separate.
the 51 notice is not a condition preceding to 9/15/14.
It is not. You are not required to send anti-item notice, but it certainly helps your claim if you do send it.
If you've done that.
Let me ask a question. The way 91514 seems to work is we all see, in almost every complaint that gets filed, there are some claims that are on their face not supportable.
Sure.
I don't see anybody, as part of this standard motion to dismiss, going ahead and asking for attorney's fees immediately with respect to those claims that were dead on arrival. And I'm assuming that if it's so clear that they do not state a claim on which relief can be granted, then it shouldn't take you very much time to knock it out of the case. So while technically I guess you may be entitled to your attorney's fees, presumptively they should be de minimis. And is that kind of why people don't just automatically add a claim under 91514 to a motion to dismiss where it's clearly a frivolous claim from the get-go?
That's a good question. And some people may not know. I think there seems to be this lore of the law that you have to wait until you get your final judgment and you've prevailed, and then you've got your 45-day window. But the reality is you can bring it at any time. So I think that strategically there may be some times when it makes sense to do that. And you're right. At this point, your attorney's fees award is going to be pretty negligible if you're just talking about responding to a complaint as opposed to discovery and everything else. But I certainly have seen people demand it at the outset of the
You have?
lawsuit. Yes, I have.
I had one matter where I think we got the claim and we detailed I think it was a co-defendant who was bringing some sort of cross-claim, and we detailed to them how this couldn't possibly exist. They went ahead and kept the claim anyway, didn't dismiss it. But we basically said, we'll be coming after you at the end of the day if we continue to incur a bunch of expense associated with the factual development that you're claiming exists but doesn't exist.
I think to both of your points, the procedure that Henry's outlined may also be important from the client's perspective. If, as the case progresses, it appears that the other side really does pursue groundless discovery and causes unnecessary expense and burden, then the client at some point is going to say, why didn't you raise that earlier? And that becomes particularly important when you get into federal court. 91514 doesn't require you to raise it, but if you've done what Henry said and at least put them on notice, then as the case progresses, if it does appear groundless, then you really put your
Be under 91514A, if you have a motion to dismiss that you don't file, and because you didn't file a motion to dismiss, you incur attorney's fees, while the court may be obligated to award your attorney's fees, I assume the court determines what's a reasonable attorney's fee under the circumstance. And if you basically ran up attorney's fees because you didn't file a motion to dismiss, I would be surprised if the court were sympathetic to that.
Well, this is another argument for doing it earlier.
Yes.
I'll throw out to Mickey's question, though, having represented banks in the past, in some cases where we got a lot of frivolous claims by plaintiffs, one of the reasons for not putting the 91514 claim up front in the motion was purely the optics of not having it look like the big bad bank was coming against the little guy, but that didn't mean we hadn't made noises to the opposing counsel that something like that might be coming, but there is an optics issue sometimes.
There is, and a lot of the big banks are very, very sensitive to that. And in my case, when I represented Chase, this was the second time that Chase had been sued by this guy with the exact same allegations. And they had offered money to settle it, and he got greedy, and it made him mad, and it made me mad. And we said, he's not going to sue again. This is not going to happen, third time. And that's when we filed the motion. But Chase was prepared to stroke yet another check for another frivolous lawsuit. So yes, optics can be a consideration, especially when there's a David and Goliath type of perception.
One final question, and then we'll get along to Vanessa. On appeal, since it's an abuse of discretion standard, does that also, in your observation, reduce the probability of the Court of Appeals taking the appeal because they would have to find a lot higher standard to reverse the decision of the trial court?
That's a very good question, and I think that they just consider it. I think they just consider each case. I mean, they will consider it on the merits and decide whether they think it's a valid decision or not. But I'd like to think that they just give it its due consideration as each case comes up.
If you didn't have a finding of fact and conclusion of law, or if the court had issued the appeal issued the award without doing a hearing, for instance, that would be a lot cleaner grounds to claim a discretionary appeal right, as opposed to the judge was just wrong. I would think. Okay, why don't we go on to 51780? Thanks so much.
Sure.
Hello. So there's been some great discussion about how to procure attorney's fees for 91514. And I'm here to just distinguish that from an abusive litigation claim or cause of action. 91514 is a court-imposed sanction for misconduct in a litigation, while the abusive litigation statute provides an entirely independent cause of action upon the successful termination of the action. And so what distinguishes abusive litigation is that you have to bring it after final termination of the action, which has been defined as a judgment when final after appeal. So you can bring it up to a year after your final appeal.
Is that an entirely separate lawsuit?
It is. And so cases have found that presumably you can get a jury trial on it. So if you are in a particularly egregious case, then this would be a great opportunity to get in front of a jury for them to sanction the other side,
And who
as
can
opposed to
you
just
sue?
a judge.
Who can you sue with this claim?
The party or the attorney. And
Can you sue anybody else?
that's a good question. That's a good question. But I think they have to initiate, the way the statute is written is, I think you're correct, maybe it allows for suing someone else. Thank you. The statute says any person who takes an active part in the initiation, continuation, or procurement of civil proceedings against another shall be liable for abusive litigation. There are two elements of this claim against them. One, they have to have acted with malice, and two, they have acted without substantial justification. This is interesting because malice is being introduced into the claim as opposed to the 915-14 elements, which doesn't mention that sort of inference of intent. Malice is defined as acting with ill will or wrongful purpose and may be inferred in the action, and so on. You can read the language. But wrongful purpose is also defined in the statute as attempting to unjustifiably harass or intimidate another party or witness to the proceeding, or attempting to unjustifiably accomplish some ulterior or collateral purpose other than resolving the subject controversy. So it really is a large window of opportunity to bring an action. However, there have not been any cases that I can find where it was successfully litigated and appealed and discussed on appeal in a way that we can really see what would be a successful case. Hopefully someone else will find one. But some other things I wanted to talk about are the notice requirement that Frank, I think, brought up. There is the notice requirement that has actually kicked out of a lot of cases on appeal because the other side was not given a chance to withdraw the action. So what you have to do as a claimant is you have to send a notice by registered, certified, or statutory overnight delivery to the other side saying why it's abusive litigation and giving them an opportunity to cease, desist, or otherwise withdraw and retreat from the offending behavior. Once you do this, again, your claim will not be ripe until 1 year after final determination. And this includes situations in which you were dismissed from the action before final termination. So you cannot bring an action if you were dismissed during it. And as far as the measure of damages, the attorney's fees, how the court determines attorney's fees is similar to 915-14. Oh, actually, the statute provides that it will be the same standard as 915-14. As far as your other damages, this is supposed to include loss of property, damage to reputation, some other additional tangible loss. Also can include defendants' damages to a defendant's professional reputation, their business income or revenue. But of course, they all have to be tied to the abusive conduct. So I think showing perhaps that connection can be a challenge.
Is this separate tangible damage, is that an element of the 51-780 claim? In other words, do you have to have that, or can you sue just for the attorney's fees you incurred in the previous litigation?
It appears you must plead other damages, but it does seem to work in conjunction with 915-14 because you can also plead attorney's fees. So yes, you must show other damages or plead other damages. But that's actually a good segue into how I wanted to say how it interacts with 915-14, because if you are starting out in a lawsuit and you think that you have a good chance to win a 915-14, you are better off trying to bring the 915-14 within your 45-day window as opposed to waiting till the end. And let's say you try to bring your abusive litigation claim and the court finds that your other damages aren't any good and you only have your attorney's fees. Well, you've kind of lost, you risk losing your attorney's fees claim.
So if you
Interestingly
can't
enough,
prove those
yeah.
additional damages, then you
Yeah.
also lose your attorney's fees claim under 5178.
Yes, because you have to bring them together, is what the understanding from the way the statute is read. Another interesting issue is, of course, before you bring your 91514, is to consider that later on, if you lose your 91514, you could be collaterally estopped from bringing that issue up again. So that's another thing to consider in a judgment call. As far as interesting cases, one of the defenses to abusive litigation is proceeding in good faith. As an attorney, we have a duty to make reasonable inquiries, and if we, upon doing this inquiry, if we discover something that completely exonerates the person, then we have a duty to advise our client not to proceed with the litigation. So that's a consideration, and a very good defense to abusive litigation claims. One case that I read, the litigant, a non-attorney, just submitted an affidavit saying they're not an attorney, they only proceeded based on good faith and so on, and the other side did not refute it, and that was found to be sufficient defense. Another case was a foreclosure case in Florida where one of the title holders, or presumptive title holders, was in her answer she said that she had quitclaimed this title. So from the answer, the other side should have realized, or at least investigated, whether that was true and dropped the claim against her. So that was an interesting case. And another interesting fact is that in the court, in determining if there was substantial justification in bringing the action, if the plaintiff was able to successfully win a motion for summary judgment and directed verdict and get to trial, then there is a presumption that they were substantially justified in bringing the action. I think that you can overcome this presumption by presenting evidence of fraud or some other evidence that it was based on malice, but there is a strong presumption in favor of the plaintiff if they got to trial. And with that, I wish I had more interesting cases for you, but this is the extent of what else.
I've got a quick question, and maybe it's just a thought and a question, you may know the answer to this, but does 51-780, does it apply in federal court? In other words, if there's been a federal court proceeding, can you assert a claim?
It seems that the statute does not limit it does not limit it in that way. So I don't know if anyone else has experience with.
Well, I know some of the attorney's fees provisions, for example, under Florida law, have been interpreted by the federal courts in Florida as providing a basis for attorney's fees in federal court in Florida, but that's because they were interpreted as being substantive rather than procedural. And I know the history of the Yost versus Tolrock and abusive litigation was to create a substantive tort. So it would seem as though that cause of action, if you had otherwise had subject matter jurisdiction, could be asserted in federal court. But again, or even possibly asserted because of abusive litigation in federal court. But obviously, you have to meet the procedural requirements of 51-780, which is providing the notice in the underlying litigation. So that may be, I guess what I'm thinking is that may be an argument for being sure that you include that notice under 51-780, whether you're in federal court or in state court, so that you preserve your right later to bring an abusive litigation claim, if that's what seems to be appropriate.
I would agree with that, yeah.
I think we ought to drill down on this notice a little bit. Typically it would come up during the circumstance where you're in litigation and there's a lawyer on the other side. But does the notice have to be in particular to each potentially liable person? In other words, you
That would
send
be
it,
best practice.
so you would send it to John Doe Esquire in his individual capacity at this law firm, and then to his client in its capacity with the lawyer representing the client. And then if there was a third party, let's say there was somebody funding the litigation that you claim was completely frivolous.
That brings up an interesting consideration, since ethically we're not supposed to be sending correspondence directly to a person if they're represented. So I guess the question would be, can we still send this notice? Since we're required to in a way?
Well, we just sent one to the attorney and also to the client, and the letter said we are ethically prohibited from communicating directly with your client. We therefore trust that you will forward this letter to your client.
That's what I was about to say. Should you put a demand or something in there to the lawyer saying you better show this to your client?
Exactly.
Yeah.
But I think it would be a terrible mistake to send that notice directly to the represented party.
In fact, I think I can't remember the circumstance, but it was something similar to that, which I didn't send anything. But I remember a lawyer complaining about a notice. It was something like a notice under a contract that had to go directly. It said it in the contract, had to go to the opposing party, but they were already in litigation. It was an executory contract. The lawyer went berserk, of course, when the lawyer for one party sent it directly to his client. But then again, how do you get around that? If you don't have any confidence, the lawyer is going to go ahead and send it over to the client. It could be a major problem. If it's a condition preceded under the contract or something of that nature, and it's an executory contract, and y'all just have to be in litigation at the same time you're fighting over the contract.
I think the client would be hard pressed to argue that you did not get notice when the letter was sent to the attorney in compliance with your ethical obligations.
Specifically tell them.
Right, exactly.
As the client's not
I'd
in
rather
the way.
take that risk than the risk of being in front of the bar association.
Yeah, but unless you fail to do it, and you didn't get the $1 million your client was supposed to get, and you got sued by your client for not satisfying the contractual terms.
Draft a similar notice and have your client send it directly to the
Yeah,
to the
okay.
attorney.
There we go. That makes sense, of course. Anything else on 5178?
With the abusive litigation, is there a defense to that claim similar to the opposition to the 915-14 motion that the plaintiff was acting in a good faith attempt to expand the law?
Yes, for the attorney, but it would be a more difficult argument for a non-attorney. Or maybe easier, it depends, but it would probably be more difficult actually. So for an attorney, it's a similar it's the same standard as 915-14.
I'm curious about how, that seems like such an easy thing to say. If I get hit with a 915-14 motion, or I get sued for abusive litigation, it seems almost too easy to be able to say I'm trying to expand the law. Has anybody seen anything that bears out exactly what that
Well,
means?
there are certainly limitations to that. I think the judge is a lawyer too, so I think you would have to make a very good, I'm looking for the language. But I guess, do we have the 915-14 language? But it has to be a justifiable expansion, or a defensible expansion of the law. I don't think it can be completely you have to have a belief, a reasonable belief.
And I
Yeah,
I
think,
think I have the language actually.
go ahead, Don, I'm sorry.
Vanessa, you were looking for the 915-14 good faith language.
Yeah, yes,
In
please.
Part C, it says, if it was a good faith attempt to establish a new theory of law in Georgia, if such new theory of law is based on some recognized precedential or persuasive authority. So in other words, you have to say, based on this old Georgia case or based on this Texas case, this is the way I think Georgia courts should go. You can't just dream it up.
I think it needs to be clear from the outset. I've seen at least a couple cases where the law simply didn't apply, and the plaintiff just omitted the part that didn't apply. And I think had that plaintiff included it and said, ordinarily we'd be excluded from this type of a claim, but here's why we think the law should be changed, then they would have that argument. But once you take some step like omitting it or mischaracterizing or misquoting it, I think you've foreclosed that type of defense for yourself.
We very briefly are going to cover, thanks to Vanessa, I think that covers that pretty well. We're going to briefly cover something I definitely don't want you to be ignorant of, which is OCGA 91168E. Anybody who has brought a claim during a litigation against under that statute?
Is that the
Oh,
office?
Becky has. Not under E. Under E.
Well, I don't know if it's under E. It's under 91168.
Amazingly.
Is that during the trial?
Yes, this is the part of 91168 that nobody talks about. This basically what this statute provides is that if you are the winning party in a lawsuit, in a trial, let's say even a jury trial, say you're a plaintiff and the defense in its normal course has raised like a gazillion affirmative defenses saying everything under the sun, every reason why a tort should not stick, and you win a judgment or a verdict, then you say, well, Your Honor, I'd like to make a motion to find all those affirmative defenses that were raised to have been frivolous. And utilizing the basic standards of 911-15-14, you then try to the finder of fact, which would be the jury, for them to reach a determination of whether all those defenses that were raised by the defendant were frivolous. And the frivolous standard is, as I said, extremely similar and directly tied to 51780, as a matter of fact. So you would have to show that it says frivolous claims shall include but are not limited to the following: a claim, defense, or other position that lacks substantial justification, 915-14B, right? Or that was not made in good faith, or that was made with malice for a wrongful purpose, and as those terms are defined in Code Section 51780. And it goes on, a claim or defense or other position with respect to which there existed such a complete absence of any justiciable issue of law or fact that it could not reasonably be believed by the court that a court would accept the asserted claim, defense, or other position. It's 911-15-14A. A claim or defense or other position that was interposed for delay or harassment, B, 915-14B. Damages awarded may include reasonable and necessary attorney's fees and expenses of litigation, and a party may elect to pursue either the procedure specified in this subsection, that's 911-68E, or the procedure specified in 915-14, but not both. So I actually was talking to a friend of mine who's a plaintiff's attorney. He goes in there, tries a case, gets a big verdict, and just as the other side's about to sulk out of the courtroom, he goes, "But that's only half the trial. Now I'm trying my attorney's fees." And he, I believe, got a judgment on the attorney's fees from the a verdict from the jury on the attorney's fees he incurred in overcoming their defenses. And so this is, like I said, for whatever reason, there are no appellate cases that I found under 911-68E yet. But that is basically an opportunity, once you have a jury all stirred up and already in your favor, they just reach a unanimous verdict, to then try the fact of whether the whole case was frivolous against your client. If you're the defendant and you win, you can have the jury find that the whole case against your client was frivolous. And assuming you can get past presumably a directed verdict motion. And then similarly, if you're the plaintiff and you pound it on the defendant, you can get the jury, who's already revved up in your favor, to try your attorney's fees on all the defenses they raised, or at least the ones that caused you trouble. Yes?
Would you have been required to give any sort of advance notice like you do under 58-51-780? You want to employ that mechanism at trial?
Even though, of course, 911-68 requires a notice for the other portion of recovering attorney's fees. There's no direct tie that I can see to the provision of this notice, your offer, in order to take advantage of 91168E, because it's a completely different underlying standard of liability.
How about a pretrial order? Wouldn't that ordinarily
I was thinking through that. I believe you would have to list this as an issue for the jury, anticipated issue for the jury in your pretrial order. Whether that would, whether a trial judge at the end of the day would hold you to that, I'm not really sure, because it's such a contingent thing. But then again, so is everything's contingent on, like a 13611 claim is of course contingent on getting past a directed verdict motion as well.
Would the jury need to have special verdicts or special interrogatories on the elements of that claim? In other words, if there was a complete lack of whatever the language is in 915-14.
They'd have to be instructed, obviously, but I don't know if they would need special interrogatories.
Sounds like it'd be a second phase, like having a punitive.
If you just have 5611, you don't have to have special interrogatories for the jury, and 5611 just ask whether they're going to award the fees.
I see that, and the only reason I ask that is that 915-14 does require those special findings.
Yeah, that's purely a judge making findings.
Correct.
Yeah.
Because my reaction is a jury thinks they're done, and as you said, they wait a minute, now we've got to go to phase 2. I would think they'd be ticked off.
Well, yeah, I don't know how to deal with that. You try your case real efficiently and really persuasively. So, Leanne?
Question, Henry, in the example you cited at the beginning where the defendant throws the kitchen sink defenses in the answer to cover their bases and then goes to trial, do you feel like you would be protected by including in the pretrial order only those defenses that you're actually asserting at trial? Does that insulate you from somebody standing up at the end of trial saying, wait, there's more?
I have no idea. Depends on what you had to do during the course of the litigation. If you had to deal with that and ask every witness, state the basis you claim that the plaintiff was contributory negligent, contributorily negligent or whatever, I don't know why that wouldn't be an attorney fee that you accrued during the course of litigation that you ultimately would be able to recover under 91168E. Exactly how you would segregate all those out, except for, usually they put in everything. They put in assumption of risk, statute of frauds, even if it's a tort claim.
Yeah, I guess I'm thinking more, even in some of the contract and boilerplate ones, that once you do the investigation, you determine they don't apply, but people don't always go back and clean up your pleadings. You take care of that in a pretrial order by saying, here's the issues that we think are going to be litigated at trial, so maybe you're covered on the no harm, no foul, because those issues weren't actually litigated. But I guess I'm sitting there, I need to go back and start, deleting defenses.
Well, if the plaintiff didn't move for
yeah, exactly. Nobody moved.
Yeah, I would say if they were so frivolous, you should have moved.
Yeah.
Well, that's actually a good question. Let's throw this out there for the second. If an affirmative defense is raised in an answer and you just don't put it in your pretrial order, is that a voluntary dismissal of the affirmative defense? Is it just an omission? If you raise it at if something comes up at trial associated with it, you barred from raising that. You may be barred from raising it at trial. Does the 45 days on 915-14 motion start to run if they omit a defense from a pretrial order? Has anybody got a comment on, like, if you only have 45 days from the termination of a claim or an affirmative, if somebody just omits it from the pretrial order, do you have to move from under 915-14?
No, it's final disposition of the action.
Right.
Okay, so it's the action as a whole.
Action as a whole.
Okay.
In fact, if you dismiss it and it later gets refiled, it's the final dismissal of the renewed action that actually starts the time running.
Okay.
Doesn't the pretrial order always say this supersedes all prior pleadings?
It does.
It does.
Like we had up in Blairsville, who decided on her own to charge on affirmative defenses that the defendant never raised, and were not in the pretrial order, that she thought were appropriate for the case.
Well, so, yeah, if the pretrial order supersedes all the pleadings, that doesn't take away all the litigation that took place before the pretrial order that may have been over totally superfluous matters that somebody just came up with all this stuff that you then had to dog down the facts on. So, I don't know what the answers are to some of these questions. I would love to have a fabulous verdict that I then followed with a 9/11/68E motion to try before the jury so that we could find out and have a good verdict on 9/11/68E in my favor so that somebody else could appeal it and see how good it was. But other than that, I'm not exactly sure what the answers to some of these questions are. But essentially, I would say the summary of it is, it appears that this allows the litigant to substitute the judge with a jury under a 9/15/14 motion, essentially.
And it seems to me it would be almost always the defendant who is considering doing that, because if you're really a successful plaintiff, one way or another, you probably got your attorney's fees claims in front of the jury.
Well, not necessarily. I mean, there are a lot of, if you're a successful plaintiff, the court could very easily find, if you had a 13-6-11 motion, could fairly easily find there was a bona fide controversy regarding something.
But then the jury would turn around and give you attorney's fees because the defense were foolish. It just seems to be...
Well, it'd be the jury to do it, not the judge. That's why you'd want to get away from the judge, get the jury to do it.
How would the jury even do it? Would you have to have expert witnesses to testify on whether these are justiciable controversies that people should respect?
I don't know. Good question. Well, there would be the question whether the other side would be prepared to have that expert.
You have to put it in the pretrial order.
Okay, so this sort of highlights the reason why I brought this up, because it's very rarely used. Apparently it is being used, though, by people that are on their toes. And so it also could result in, for instance, you could propose this motion. The judge may say, oh, gee, it's 5 o'clock. Well, come back tomorrow to deal with that. And you might end up getting your judgment paid that night in lieu of going back to try the attorney's fees remainder of the trial. I don't know. You could use it in various ways if you're the plaintiff, and possibly in various ways if you're the defendant.
One comment I'd say about all of these ways of getting attorney's fees, I think more and more clients are becoming, our clients are becoming sophisticated and understanding that there are ways to get attorney's fees, and they may not understand the intricacies of it, but they have an expectation. And so it's important to inform them in a timely manner that these different procedures are available, and be sure you've covered it with them, so that at the end of the day they don't say, well, that was a great result, but now when do we get our attorney's fees back? And then you have to say, well, we might have done that had we done something 6 months ago. By then it's too late.
But while you're doing that, make sure you explain that and I agree totally with Don, but make sure you explain that it's an extremely high standard at the end of the day under these frivolous litigation statutes. You're not going to get them just because the other side was mean or wanted more money than you thought they should get.
Correct.
So, all right, well, I think that pretty much uses up all of our time, but thanks so much to Don Boyle, Catherine Banich, and Vanessa Suh for handling this.